Just a question out of curiosity. Have either one of you ever been working in the private sector and ever made a loan on a housing loan?
Congressman, I've worked in the private sector serving banks.
Serving, what do you mean? Have you ever made a bank? Have you ever made a house loan?
No, Congressman.
Ms. Cochran?
I was in private practice, mostly for financial institution clients prior to going into government.
But you never made a loan?
Not
okay. Just out of curiosity, one of the things we're working with here this morning is the results of the low doc loans. We went in and we thought we were really bright. We wanted to sort of make it all quick and easy and available. The system was working, and now all of a sudden we have low doc loans, and now it's all messed up, and now we're trying to fix it. That roughly right?
That's certainly one of the concerns.
One of the problems we have? Okay. So as we try and fix this, you now have been directed by the law the Congress passed to try and come up with a rule for trying to figure out how qualified mortgages come up with a standard. I guess the question is, and I have this difficulty sometimes with a lot of individuals who serve in the bureaucracy from the standpoint that interpreting those laws sometimes can be difficult, and the intent of Congress. And when they make a rule, suddenly they believe that's the only way that this rule can be made, and they become very inflexible. Do you have enough flexibility that you believe with the way this rule was, the law was promulgated, the law was put before you, that you have that flexibility to be able to make the changes that can accommodate the things we're talking about this morning?
We structured the rule in a way that specifically provided for flexibility.
I'm not talking about the lenders. I'm talking about you. Do you have enough flexibility to go back and make the changes we're talking about this morning? Because we've talked about a lot of things. We've talked about, Mr. Watt talked about the 3%. Mr. Miller talked about a lot of things with regards to this. Somebody else talked about the rural definition here. I think Mr. Duffy. I mean, there's a lot of things that need to be worked on. Do you have enough flexibility to make those changes, and are you willing to do that?
We've created a structure that we believe will be helpful in considering where further adjustments are necessary in the rulemaking. One of the things that we did, in addition to creating the main definition of qualified mortgage and the temporary definition of qualified mortgage, which is not an exemption for Fannie and Freddie.
You're not answering my question. All due respect, Ms. Cotton, you're not answering my question. It's very simple. Do you have the flexibility, and are you willing to use it to make the changes we're requesting this morning and discussing? Yes or no?
We made the best decisions that we could in the rulemaking process.
Okay, I grant you. You've made your decision. Now, are you willing to go back and take a look at changing it based on the stuff we're discussing this morning?
We are continuing to consider a number of the issues that were discussed this morning in the context of the concurrent proposal. And as I discussed, we want to tie that off as quickly as possible. We do believe that we have flexibility there, and we proposed those changes to make sure that we address some of the concerns that have been raised. We've also structured the rule so that as the 7 years progresses and the temporary category of qualified mortgage would come to a close, we would have ability to look at the market, how it is developing, if it is developing as we predicted, and make adjustments to the rule at that time if necessary. Okay, so
is there enough flexibility in the rule then to allow you to do that, or in the law? You feel you have enough flexibility to do that, apparently. Is that right?
We believe that we have flexibility to make important decisions and that we are continuing to use that appropriately, yes.
Okay. Wow, no wonder we can't get anything done here. We can't get any straight answer. Okay, with regards to the level of participation you anticipate by the different groups, agencies, you've broken it down to different banks, small lenders, big banks, mortgage lenders, and we've had three or four different numbers thrown around here this morning with regards to participation. It would seem to me by the definition of a qualified mortgage and the safe harbor that it provides, that those loans that are made outside that safe harbor would then have an inordinate amount of liability risk for the lender, would they not? Would you not believe that would be the inference from protecting and having a safe harbor for those that are made that way and those obviously that are not? Wouldn't you believe that would be the case?
Congressman's a very good question. We calculated what we believe the litigation risk might be in our 1022 analysis for non-qualified mortgages, and then there's a lesser amount of litigation risk for qualified mortgages that carry a rebuttable presumption of compliance.
Well, where I'm going with this is if there's more risk, inherent risk with those mortgages that are made outside that, and the lenders then are less willing to do that, there's going to be an access to credit problem if you have an access to credit problem, where are they going to go? They suddenly will go to agencies like FHA, which are making loans, according to this testimony we've heard in this committee before, that are kind of like Freddie and Fannie were making, that are kind of beyond the scope. And now we're going to wind up forcing them into a government agency that's already in trouble. And so this is a self-fulfilling problem with the way we're structuring this. And I see I'm out of time. I appreciate the indulgence of the chairman. Thank you.